The Attorney-Client Relationship, Part 1. Lawyers, Lawyering, and Litigation. Dr. Peter Baxter, Law and Jurisprudence Program, Spring Semester 2015. Well, as you could tell from my voice, this is Dr. Baxter, but my voice is all but shot. So I'll give this a try. I hope that it comes out clear enough for you to learn from it. And we can also use it as a basis of discussion when we get back together. Perhaps the central importance of the attorney-client relationship and the key issue that usually causes frustration between an attorney and a client is the attorney fees. Very seldom do you hear a client argue that the attorney fee was low. And if they do, they keep it to themselves. So what I want to concentrate on in the first part of this lecture series is to look at the attorney fees, the types of attorney fees, and some issues that you have to approach in contracting with an attorney in terms of the fees. Generally speaking, there are three types. Even though there's permutations of each, there are three general types of attorney fees. You have the contingency fee, you have the hourly fee, and you have the flat fee. Just remember, though, that there's variations on each. The first I want to look at is the contingency fee. And you normally see a contingency fee when you see a percentage. The contingency fee provides for compensation to the attorney for his or her legal services based on a percentage of the recovery, meaning what the client wins ultimately in the lawsuit. The attorney gets a percentage of the recovery. Now, where do we find contingency fees? Well, they're typical in personal injury cases, and you see these commercials on television all the time. This type of arrangement is typically used for personal injury matters like negligence, car issues with the car, or slip and fall accidents. But it can be used in other types of matters as well. But by and large, most personal injury fees are premised on a contingency fee. The fee can range anywhere from 25 to 40%. Typically, it lands around at the 33% or the 1/3 of gross amounts recovered. So, if the client does in fact win, the attorney walks away with 1/3 of the profits from that lawsuit. Now, contingency fees, like all these fees, are in fact negotiable. So you can negotiate the actual contingency fee. The client would enter into negotiations with the attorney, preferably right at the onset of the lawsuit, so there's no lack of clarity. Usually the fee is related to the likelihood of recovery and the amount of that recovery. So likelihood of success is key in determining where should the contingency fee stand. Thus, if it's obtaining a favorable result will be difficult, the fee percentage will usually be higher. The lawyer has to do more work to get a favorable result. Thus, the fee percentage will probably tip towards the 40%. If the recovery amount is going to be small, the fee percentages the fee percentage may also be higher. If the amount will require significant time and effort, the likely amount recoverable is small. The attorney probably will not undertake the representation at all. So, at some point, an attorney might not see a future in the specific lawsuit, and nothing on the fee range would satisfy the attorney. Now, one important issue is distinguish, especially in the onset of a lawsuit, whether the contingency fee will be premised on gross amounts gained or net amounts. Now, what's the difference? Gross amounts refer to all the amounts that are received from the opposing party. If you have expenses that you want to offset from the percentage of the recovery, you spell these out in the agreement. So, in other words, the net amount are the gross amount, and the after the net amount is the gross amount after expenses have been deducted. So any type of court costs, expert witness fees, copying costs, investigative costs, things like that, go into the overhead. So gross is the total amount, net is the gross minus the overhead. All of these things like court costs, expert witnesses, and the like. Now, we also have a modified contingency fee. Like I said before, many of these fee structures have variations on them. And one we see in the modified contingency fee. In this situation, hourly rate is used as well as a contingency fee. So it's a combination of the hourly rate and the contingency fee. The hourly rate is greatly reduced, and the percentage is also less. Although there could be variables as well as offsets. The modified contingency fee provides the attorney and the client the opportunity to go forward with a case in which the probability of recovery is not great or the likely amount of recovery is limited. It can also be used when the case may take a substantial period of time to resolve. So a modified contingency fee has a mixture of low hourly fees and low percentage contingency fees in a mixture. Now, what are some of the reasons for this? Well, there's less like I said, there's less probability of recovery, and recovery is in fact limited. So it satisfies both the client and the attorney in arriving at a relationship that might take some time to win. Now, moving on. Attorney fees 2. Here we look at the hourly fee. The hourly rate that attorneys charge depends on a number of factors, including the subject area of the case. Patent law, for instance, is high ticket hourly, while matrimony will be in the lower area, like 350 an hour or like. But it depends on the subject matter of the case, years of experience of the attorney. If you've been doing this for a long time, you know how to do it correctly and quickly. Thus, your hourly rate will reflect in terms of a higher rate for a seasoned attorney. Also, the hourly rate may also be high if there's a great complexity to the legal issue before the court, and also if there's a general overhead of many additional costs to the attorney. This too might be reflected in the hourly fee, especially if the attorney is going to charge the overhead off the amount he gets instead of charging the amount directly to the client. But remember, like all of these fees, they're also negotiable. You can negotiate, a client can negotiate with an attorney with the attorney as to the hourly rate. It's negotiable. The more the attorney sees the benefit of handling the matter, whether the benefit takes the form of fee generation, potential clients, referrals, or publicity, the more likely the hourly fee will be adjusted. So if the attorney will gain more than just merely the hourly fee in terms of notoriety, positive press coverage, and the like, he or she, the attorney, may lower the hourly fee because he or she is getting compensated in other ways, getting their name out there, getting some photo recognition, hopefully for the good, in terms of the popular press. Now, how does one estimate an hourly rate? Well, a good way to do so is to visit the attorney's office. What kind of expenses will be associated with the case? What type of overhead, like I stipulated before, would relate, including such things as amenities, secretarial and support staff, all of these things have to be reckoned into the issue of overhead. Differences in costs between one attorney and another could be nothing more than merely the overhead. You might have two attorneys with a similar amount of experience in a similar legal issue, but one operates with hired help for each case, while others have in staff secretarial support and the like. So it's not unusual for an attorney to budget more than 60% of his income for overhead. So in the amount that he charges, he expects to take back only 40%, and 60% would go to all those other overhead issues and secretarial support issues. Now, you cannot underestimate risk assessment when it comes to the hourly fee or any form of legal representation, but it definitely affects the hourly rate. If the subject area of the case is one of high risk to the attorney, especially one that exposes him or her to liability, then it's likely that the hourly fee will be greater. Obviously, the attorney is taking risks in representing the client in areas where his or her, the lawyer's ethics might be challenged, or he or she might become liable. Examples of potential risk scenarios involve securities and exchange, highly volatile issues like that. At times, estate planning, not the initial creation of the estate, but what happens thereafter. There's great disputes between family members, as we all know, when an estate is disputed. Also, tax and real estate issues at times become very very caustic, very ugly, very acrimonious. And in those circumstances, the lawyer might be held liable for, either rightly or wrongly, for misrepresentation or underrepresentation, or just being a bad lawyer, because one side doesn't want to blame a family member, they want to blame the lawyer. An attorney's liability insurance rates go up whenever they get into this high liability area, these high liability areas. And since their insurance rates go up, the staff needs are greater in such cases to cover, to make sure they have a solid case, and thus the expenses go up. Now, we have a problem, which is actually a solution, with criminal cases. Strangely enough, the liability of the attorney representing the criminal client is much less. Generally, the attorney is given more discretion in legal matters concerning criminal law. And the strange thing here is, unless the attorney is how would I put this? A prison Joan of Arc, somebody who thinks that everyone is guiltless. If the lawyer steps within the boundaries of criminal law, then the liability for error is usually much less obvious, or much more difficult to prove. There is a set procedure, as we know, in criminal law, more so than civil law, which tends to flow depending on the circumstances. Thus, the legal costs typically are considerably less, and the hourly fees are criminally, the fees are thus typically less than they would be in other areas of the law. There are exceptions, obviously, to fees, and we talked about some of these. Security or tax work in the criminal area can be very costly in hourly. So if you have embezzlement issues or other forms of where you need to do taxation or corporate forensics, then you'll need to charge at a much higher rate or a much higher level simply because you'll have to bring in typically forensic accountants, um, tax specialists, and the like. Some attorneys bill a minimum of certain tasks as well. For instance, if the attorney has to make one phone call, all phone calls are considered 15 minutes. So when you're billing at 350, 400 an hour, one quarter of that is just for one phone call. Um, Even a voicemail message is considered 15 minutes standard. Retrieving email, sending email, 15 minutes standard. So you can see how the charges rack up. And in securities and exchange and tax work and the like, you're going to be making a lot of phone calls. You're going to be dealing with a lot of other staff members outside your office. You don't typically keep, unless you're a tax firm, you don't normally keep forensic tax specialists in your corral. So you have to go out and get them. You have to talk to them. And every time you talk to them, boom, ching, more cost for the client. Now, in some areas of law, the attorney and the client might come to an agreement in terms of equity arrangements. An equity arrangement is when the attorney receives part of his or her fees in equity in return for his services. So the attorney works for the client, and in return, instead of you get a much lower hourly rate, but the attorney then has equity within the arrangement. We find this typically in business arrangements. Um, Usually, when a party is establishing a business, the business founders, to keep their costs low in the initial establishment of the business, might enter into an equity arrangement with an attorney who will represent them over time. Thus, their attorney fees are much less at the founding of their business, incorporation, things like that. In return, the attorney might end up with a percentage interest in the business, or later, if it becomes a stock interest, it'll be reflected in a percentage of the stock within the company. The final pure type of attorney fees is the flat fee. These are most often, just like contingency fees, you find mostly in personal injury cases. Flat fees you most often find in criminal cases. But sometimes you'll see flat fees too in incorporation, in estate planning. Not in estate disputes, but estate planning, laying out the initial estate, or the drafting of a will. Now, the flat fee, though, has some particular interests on the part of the attorney. For instance, in criminal cases, the attorney needs to get as much of the fee up front. Experience typically shows the attorney that there are some horrific consequences to a criminal proceeding. And the client may initially promise the world, but normally the money isn't there. So what the attorney needs to do is try to get from the criminal client an initial payment up front, a large one, so that just in case the criminal client doesn't pay the attorney anything more. So the flat fee in criminal cases initially will look larger than in other cases. Now, this is ironic because you don't get the large upfront fee if your criminal client is a repeat offender. Because if, think of the mafioso. Think about the attorneys they had representing them over a 10, 15, 20-year period. There you have a criminal corporation in the sense. You have a criminal family, a mobster family, who are repeat offenders. They retain attorneys that become their mouthpiece. And in that regard, the initial flat fee will not be as large because they know that they're repeat customers. Repeat offenders are repeat customers. It's quite simple that way. Now, in corporate cases, you'll find that the attorney is also paid a substantial retainer. Now, in corporate cases, you're talking about the ongoing creation of a corporation and the initial management of the corporation, and perhaps the ongoing flow of business within and through the corporation. Here, the attorney is normally paid a substantial retainer if they are, in fact, separate from the corporation. Now, you know that most large corporations have an entire plethora of attorneys on staff. We call that, of course, in-house counsel. But I'm talking about the attorney that's out of house counsel, meaning a private attorney who is contracted by a corporation to represent the corporation. We also see this in estates, because obviously with estate planning, you have the formation typically of a trust, some form of trust, which is an incorporation of the interests of the decedent, of the dead person. So in other matters, such as estate planning or the formation of a corporation, a flat fee is paid at the time the relationship is formed, and then the remainder of the fee is paid either monthly or upon completion. So you have a flat fee paid at the time the contract is formed, the contract being with perhaps the executor of the will or the person designated as the attorney for the estate, or the individual that has been contracted to incorporate the corporation if it's a business interest. Flat fee is paid at the time the contract is formed between the attorney and the client, with the remainder being paid monthly or upon completion of whatever the issue is before the estate or the corporation. Now, before the first conference, you can actually the client, can lower your attorney costs by doing much of the footwork yourself. In fact, if you have a poor attorney, you will seemingly feel like you're doing all the work and they're doing very little. If that's the case, obviously, find another attorney or report that attorney for dereliction of duty or underrepresentation of your interest. Now, how, before the first conference, once you've decided on a specific attorney, how can you help lower your costs? Well, gather and organize as much, that should read data, not date. Gather and organize as much data as you can. A well-organized documentation presented to the attorney makes the attorney more inclined to provide a reduced contingency or a reduced hourly rate or even a reduced flat fee, because the attorney senses that you will be able to assist in the case preparation, and thus the case itself will be less difficult. The best way to gather and organize your data is to do it chronologically. This helps the attorney lay out what exactly has happened. If you mess it up, if you scramble it up, you're just making the attorney's job much more difficult. The second major aspect of this is you have to have a clear understanding of the issues before you as a client and your goals as a client. You have to try to develop a clear understanding of the issues and matters for which you're seeking legal advice. Ask yourself this: what will the attorney need to know to determine whether to undertake representation? Now, one way to do it is to speak to others represented by this attorney. Each attorney has their own style, has their own ability, their own joie de vivre. And because of this, Sometimes attorneys are not a good match to a specific client. If you need a hand holder and you find one who isn't, then you'll feel like they're not helping you. Vice versa, if you want more control in your litigation and basically assistance by the attorney, you might not want someone who dominates in the lead up to the trial, if there is going to be a trial or a plea bargain. So talk to others represented by this attorney to get a feel of how they act, and determine if it's a good fit for you. Finally, we have to come back to the American Bar Association and the model rules. Everything when it comes to attorney fees is premised on Rule 1.5, and the focus is on reasonableness of the fee. Reasonableness. Just like the reasonable person standard. Is the fee reasonable? Now, the American Bar Association, since its model rules, lay out factors. They don't say a specific dollar amount is reasonable or unreasonable. They lay out factors in determining whether fees should be higher or lower. Some of these factors include, well, I'm going to give you the almost the exhaustive list. First, these factors is the amount of time and the labor required by the attorney to represent the client fully. So time and labor costs. The novelty of the legal issue. Novelty is not a good thing because that means you're probably challenging precedent in one way or the other, which of course makes the legal issue difficult. You might start from a difficult position, and a lot of the pretrial might be you having to develop a stratagem in terms of defying precedent and laying out a new tact, if you will. Also, certain skills might be needed that are highly valued. For instance, a patent attorney has the skills of normally having either a biochemical or kinetic physics background, and you basically market that to the highest bidder. Individuals that are estate planners for 20, 30 years are well schooled in all the minutia, if you will, tax experts in the code and the like. So the skill requisite to perform the legal services properly also factor in. One other aspect you have to think about here. Will the attorney's employment for you, the client, preclude this attorney from getting other jobs or being able to handle other jobs? If you expect and if the issue will take over the attorney's life 24/7 for 6 months to a year, obviously the reasonableness is you're fully employing that attorney every waking moment to represent you, to the detriment of other jobs he or she might have taken had it not been for your huge legal issue. Also, fees are reasonable if they are customarily charged in that region. Attorney fees in Buffalo are lower than attorney's fees in New York. Attorney's fees in New York are commensurate with attorney's fees in other large metropolitan areas. So you will have to also look at what is the typical fee being charged per hour or per subject matter in that specific region. The other thing on reasonableness is the amount involved. If it's a low risk, low sum potential finding, obviously the fees should reflect that. You're not going to get a $100 client victory and expect an attorney to eat all of that in terms of time, unless they're doing it pro bono, which means for the good. And the ABA does have guidelines in the New York State Bar on when attorneys should or their firm should offer part of their time to represent indigent clients and those who cannot pay. Obviously, another factor is time limitations imposed. If you need the attorney and all of his time for the next 3 days because you're going to be appearing in court early next week, obviously the reasonableness, the amount expected will go up because the attorney doesn't have a lot of time to work and has to push things off so as to represent you. So time limitation imposed also affects the level of reasonableness. And obviously the final factor I'm going to cover is whether the fee is fixed or contingent. If it's contingent, obviously it depends on some specific. If it's fixed, then it has to be reasonable within all of those other factors I talked about. Now, the fee, one other thing the ABA makes very clear is the fee shall be communicated preferably in writing upon commencing representation. No surprise here. What are we talking about? We're talking about a contract. And obviously we know from law that, our legal system likes things in writing because they're easy to apply the parole evidence rule, the four corners rule, if there's any dispute. So fees shall be communicated preferably, and this is the wiggle room that the ABA gives to attorneys, preferably in writing upon commencing representation. One thing is clear, though, that contingency fees must be in writing. So if you're going to set up a contingency fee, you have to talk about it right at the onset of the legal contract. When you start with your client, you have to be very clear, and it must be in writing, and specify the percentage very upfront and clear at the beginning. That way the client can determine whether that attorney is taking too much out of the potential winnings, if there is such a thing. One other thing about contingency fees in the American Bar Association rules, contingency fees are precluded in certain types of cases. So remember I gave you the three forms, but contingency fees are precluded in the following two areas. Any type of domestic relations, divorce, maintenance, support. The ABA does not want contingency fees to operate because what you're doing is it's contingent on you getting the divorce or lowering maintenance or increasing support. It smacks of something that's unconscionable, slimy, if you will. So contingency, the ABA precludes the use of contingency fees in any domestic relations, divorce, maintenance, or support. So there you could either apply an hourly or a flat rate. Okay? And the second general area is in criminal cases for much the same reasons. The attorney cannot guarantee you're going to get a misdemeanor or a low-grade felony. And if they do so, then they're abusing the criminal justice system. So just like with divorce and maintenance and support, the ABA precludes the use of contingency fees in cases where the defendant is in a criminal case. Finally, the total fee has to be reasonable. We go back to reasonableness. Just like we started this lecture series, we come back to it in the end. That the total fee, gross or net or both or either, has to be reasonable. And this is where I'm going to end because my voice is giving out. Part 1 of the attorney-client relationship, attorney-client privilege. Thanks for listening, and I hope you could make out what I was saying.